That's what I spent my afternoon doing yesterday, was reading jail reports. I spent more time on jail reports than I did PSIs.
They're more voluminous.
Same names I keep seeing.
This judge walks into the courtroom already frustrated. She's been reviewing jail incident reports all afternoon, and the names she keeps seeing are the same ones she now has to sentence.
Good morning. Are you Jayen Young? And Mr. Lewis, will your client waive the formal reading of the indictment and the motion?
He does, Judge.
Mr. Young, in cause number 250309, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up. And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1.
And the moment the defendant speaks, the judge immediately calls him out for whispering. She's already read his jail file, and it paints a very different picture than the quiet man standing in front of her now.
Before you signed these, did you go over them with Mr. Lewis? Speak up. Because let me tell you something. I bet you're not talking that low when you're acting up like all these jail incident reports tell me. When you're calling names and you're acting a fool out at the jail. So use your big boy voice and answer my questions just like you do when you're acting nonsense to those correctional officers out there. Because I bet you're not whispering to them, are you? Are you? Because how you act at the jail, how you act right now, all determines whether I even go along with this plea agreement. I don't have to. You're on a probation. I don't have to take plea agreements on any probations. If I find that you violated your probation,
This is the judge's first major warning. Your attitude right now can destroy your plea deal. And she makes it clear, she does not have to accept anything the lawyers negotiated.
I can give you anything I want to in that range of punishment. And I can say, you know what, I'm not going to let you guys negotiate. That I don't have to do that legally. So you better be careful with your faces and your words and your attitude, because I've read all of these and I already don't have a good feeling. Do you understand? So you need to give me a better feeling if you want me to go along with this plea agreement. Does that make sense? Okay. So again, before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number.
This is where the defendant realizes he's on thin ice. The judge tells him plainly, fix your attitude or watch your agreement disappear.
1 in that case?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Young is not competent?
No, Judge.
All right, so I'm going to find that you entered a plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 2137857,
Your Honor, it's a second amended. Just in the interest of economy, I would suggest we go forward on counts 1, 2, and 13. 13 being the offense he's already pled to.
so you're on probation. We've got a probation for an evading arrest or detention with the use of a vehicle. And we've got 2 more evading arrest or detention?
The second evading is a misdemeanor enhanced to a state jail. And count 20
right.
reads motor vehicle. That's incorrect, Judge. It's evading on foot with priors.
Okay, gotcha. So this shows that you were placed on probation August 29th of 2022 for evading with a vehicle, and that was a 10-year sentence in prison that was probated for 5 years. Is that correct?
And here comes the real problem, stacked probation violations. missing meetings, not working, and getting arrested again. All of this hits the judge harder because she's reviewing it immediately after reading his jail behavior.
And the state's elected to proceed on counts 1, 2, and 13. Count 1 alleges that you failed to report as directed to the probation department on October 2nd of 2024. And is that
The judge pauses to pull up one more document, the administrative report about his behavior toward probation. Whatever is in this file is about to cause serious damage.
true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
And then count 13 alleges that you were arrested for the offense of evading arrest or detention with the use of a vehicle February 26th of 2025. And is that true or not true?
True.
What's the status of the possession and the failure to ID from that date?
I believe the failure is, I think, still pending.
The failure ID is still pending next door.
And examining the probable cause affidavit from that date, I don't see that there would be a possession charge, Your Honor.
Okay.
Um,
Let me look at something real quick. What I'm looking at, just so that you know, I'm trying to go back and find which administrative hearing talks about the allegation of his behavior to, it looks like there was something that happened with probation, one of the allegations. So I want to see a little more about that. That coupled with what's been going on in our jail may or may not affect my same thing. It's the same thing. You did the same thing to your probation officer that you're doing in the jail. Do you really think that your probation officer is going to go on a date with you? Do you really think that a correctional officer is going to go, yeah, when you get out of jail, you're the guy I want to date? You got in trouble for saying and talking like that to your probation officer, and now you're doing it when you're in jail. Cursed loudly about the work you had to do for your community service, calling it slavery. You think community service is slavery? Do you think that?
No.
It's the same. I'm not taking 5 on the MTRP. I've already taken 5 on the other. Y'all can renegotiate or you can let me do it. So I'll hold everything right now. Y'all go visit some more. But that's the same behavior. We're not gonna reward that. All right, y'all go visit. I'll hold it instead of resetting it. I'll keep this paperwork, but I can make a modification if you come up with something different. But I'm not going to do that. All right, so we are back on the record in cause number 21-37857, and again, you're Jayen Young, right?
Sure.
And in that case, which is the motion to revoke probation, Mr. Young had entered pleas of true to counts 1, 2, and 13. There was an agreement for 5 years in the institutional division, which I said I would not accept. Have you guys had an opportunity to visit?
We have, Judge.
And what is the?
The new agreement is 8 years TDC.
All right, I'll take that. And Mr. Nichols, that's your agreement as well?
Yes, Your Honor.
All right, Mr. Young, again, I have some documents here, like the other case, that have your signature on them that the state's marked as exhibit number 1. And before you signed these, did you go over them with Mr. Lewis? Speak up.
Yeah.
And do you fully understand them also?
Yes, sir.
And I have made the notation with everyone's agreement on the agreed punishment recommendation page that's changed from 5 to the 8.
Yes, ma'am.
Yes, Your Honor. Thank
All
you.
right. State tenders number 1 in that case?
No objection.
It's admitted. And so, Mr. Young, I'm going to find that you entered your pleas of true to counts 1, 2, and 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with this agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. As a part of this plea agreement, I'm going to sign a dismissal in cause number 25 DCCR 0385. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. When you were here back in 2022, we went over the fact that you're not supposed to possess a firearm in Texas, correct? Okay. It can still go worse. I mean, I got 2 more years. It's not funny. It's not funny to you, but I know you're upset about all this, but the only person you should be upset with is yourself, you know? So anyway, because of the judgment entered against you, you're not allowed to possess a firearm in Texas. I've handed you that admonishment. Be sure and read it again. We already went over it before. All right, good luck to you. You can go back with the bailiff. I did it again. Y'all have got to make me stop. I just did my mouth thing again. My frustrated thing that they keep catching me off. I can't help it. That's what I do when I'm frustrated. You know what? Look, my face is turning red right now. All right, you're Christopher Bushnell? And so Mr. Bushnell has 2 cases, an evading arrest or detention with a motor vehicle and engaging in organized criminal activity, in cause numbers 25-0112 and 0113. There was previously an agreement motion, and a plea agreement for 10-year deferred probation. We were here because of the issues in the jail. I rejected that because if I were going to go along with that, I was going to order the ISF. And so we're back here. And then, so let me ask you, I should tell you what's bad is when I remember stuff, Mr. Bushnell. Your birthday's in October, right? No, December. So we're getting close. But here's the problem, Mr. Bushnell. So you were here May 6th, right? And I didn't accept these plea agreements, and I got pretty upset with you because of what had been going on in jail, right?
Yeah.
And what did I tell you?
Back with no write-ups.
You know how many write-ups you've gotten since May 6th? You want to take a guess? Too many to count. Too many to count. May 6th, you got, since then, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 more. Fighting, same things. Fighting, not following the rules, calling names. I mean, same thing. You don't like following rules, do you?
I do.
You do? What part of calling a correctional officer the names that you've been calling is appropriate? It's not. So why would you keep doing it after I told you? I told you, go just be good for a month. 1 month, be good, follow the rules. And it's one thing if you've got another inmate running up on you fighting and that was your excuse. But it's not agreements. If the jury wants to see all this and give you probation after that, that's going to be up to them. I'm not doing it. Go back with the bailiff. We'll set your case for, well, let me do this. Ms. Holmes has been appointed as your attorney, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. What I can do is release her and appoint a new attorney who can begin preparation for trial. Do you want me to do that? Or do you want to keep Ms. Holmes? All right, Ms. Holmes, get ready for trial. And let me tell you what you're doing. You're making her job hard. She's trying to help you. I wanted to try to help you. If you came in today and didn't have all this nonsense, calling, I mean, I'm looking at it over and over, calling them the B word. Not doing what you're supposed to, saying, I don't care, write me up, I don't care. If you don't care, then I don't care. Because I tried last time when we had this conversation. So your case is going on the trial docket, and again, we'll let a jury decide what to do with you. Go back with the bailiff. Good luck, Miss Holmes.